going to talk to you over the next few minutes about relinquished babies relinquished for adoption. Now, this is an interesting topic because the Court of Appeal has recently handed down a very important judgment in relation to these issues. It's a case of A, B and C. Now, it's a very lengthy judgment and this is a very complex area. I'm not going to burden you with extensive volumes of case law or guidance. What I am going to do is take you on a very short whistle-stop tour of the judgment and the guidance provided by the Court of Appeal. You don't need to concern yourself with the individual facts of the appeals. There were 3 conjoined appeals heard together, and the outcome in those cases isn't necessarily relevant when it comes to considering the guidance that should be applied to these cases. Now, the judgment is lengthy and it's provided by Lord Justice Peter Jackson. It's an excellent judgment and I would recommend you read it in full. The first key principle to take from the judgment is that welfare, whilst relevant, isn't a paramount consideration. In other words, you have to take child's welfare interests into account, as you do when considering the provisions of the welfare checklist within the 2002 Act. But when it comes to welfare is not a trump card and it's not paramount. It's one of the individual factors that the court needs to take into account when undertaking its balancing exercise. In relation to the process that should be adopted by local authorities dealing with these cases, quite correctly, local authority doesn't set out guidance that must or should be followed. What the judgment does do is set out a suggested procedure that was agreed by the parties to the various appeals that would assist local authorities in facing these situations and dealing with these cases. I'm not going to read these out verbatim, but you've got these in full on the slides. And I've tried to set out all the really crucial pieces of information. The local authority should take these steps as soon as it's notified by a mother, or indeed a mother and father, that they're expressing a wish to relinquish their baby for adoption. As soon as is very important phraseology, because in my experience, unfortunately, there are cases where the local authority doesn't instigate assessment processes as early as it should do. Local authority needs to very thoroughly check background information in relation to the parents and the wider family, and the allocated social worker, and preferably the adoption worker as well, needs to undertake a visit to the mother, or indeed the parents if the father's involved, and discuss the various factors that are set out in bullet points on the slide with the mother or the couple so that they can make an informed decision. They need to be provided with written information about post-adoption counselling services, etc. And if the father is identified and contact hasn't been made with him, the local authority needs to check all relevant background information in regard to the father. The placement team need to be notified immediately, and the process of placement finding, ideally for a concurrent placement, needs to begin as soon as possible. Another important point that's often missed is that CAFCAS need to be informed at a very early stage so that an officer can be allocated, because if parents are giving their informed consent to adoption, the relevant forms need to be completed by a CAFCAS officer. What the Court of Appeal stresses is that the local authority should really critically examine all the information it receives and indeed challenge the mother and father when necessary in relation to the accuracy of that information. The social worker needs to seek legal advice as a matter of urgency. These cases shouldn't be left and legal advice should be taken, because what legal advisors need to consider when dealing with the social workers is considering whether the matter should be put before the court, and if so, in what format. Part 19 application needs to be considered. In some cases, the interim threshold criteria may be established. However, it isn't always appropriate in those circumstances to instigate care proceedings. Each case is turned on their individual facts, but in my experience, the Part 19 process provides a really helpful and useful procedure for dealing with these cases in a non-contentious way, avoiding complications that can be caused by threshold issues. Clearly, another bonus of bringing matters to court and of the Part 19 process is the fact that the parents will be involved and have legal advice, or indeed, if it's just a mother, the mother will have legal advice. That's often something that very much assists parents in these situations in making an informed decision. And when an application is to be made, a social work statement needs to be detailed. It needs to set out the pros and cons associated with notification of the birth family, adoption, all the various issues in play. Whilst local authorities don't have to, I would strongly advise that they adopt and follow this guidance. And those representing children in these cases put before the court should really scrutinise the process that local authorities adopted and look at whether the guidance has been followed as it should. Peter Jackson, LJ, listed the following matters of those would require attention when considering applications of this nature. When allocating, the identity of the judge needs to be considered. These are likely to be cases allocated to the DFJ, Deputy High Court, or indeed the family division levels. The identification of the parties needs to be considered, as does general case management directions. And in general terms, these cases should be listed for a reasonably urgent case management hearing, ideally the CAFCAS officer to attend. That's because the risk of delay in these proceedings is obvious and it needs to be averted if at all possible. Scrutiny needs to be given to the mother's account, or indeed the mother and the father's, if the father's involved, and they need to be challenged. Often parents will say some things to support the outcome they wish to achieve, and the information provided by parents really needs to be critically examined and challenged by social workers. And the listing of a determinative hearing needs to consider what evidence is needed and what legal argument, or indeed any oral evidence, will be necessary. Peter Jackson, LJ, very helpfully summarises the key principles that govern decisions by adoption agencies or indeed the court as to the issue of notification of a putative father or indeed the extended family. This is a fast-track process provided by Part 19. It's designed to negate delay, and there is a profound importance in relation to the decision itself of adoption upon a child throughout the rest of his and her life. So careful scrutiny and attention needs to be given to the decision-making procedure. The decision should be prioritised and the process characterised by what Peter Jackson, LGA, describes as urgency and thoroughness. The decision maker's first task is to establish the facts as clearly as possible. And once the facts have been investigated, a fair balance needs to be struck between the various interests involved. The welfare of the child, as I've said, is important but not a paramount consideration. And there is no single test for distinguishing between cases in which notification should and should not be given. But what the case law does show is that the relevant factors are as follows. Parental responsibility. If a father has parental responsibility, that's a very strong point in favour of notification if the putative father isn't aware of the child. The Article 8 rights, the child and the family, father and mother, are relevant. If the father and mother are married, that's obviously relevant when considering the strength of the Article 8 ties and the Article 8 rights involved. The substance of the relationship. Was the child conceived as a result of a one-night stand? Was he or she conceived as a result of an enduring relationship? Again, questions that are relevant. The likelihood of a family placement being a realistic alternative to adoption. And again, that will come down as to what information is known about the extended family and how, if at all, is that being scrutinised by the local authority and indeed the children's guardian. The physical, psychological, or social impact on the mother or others of notification being given. That ties in with the issue of cultural and religious factors, in my view. Is this a case where having a child out of wedlock will result in the mother, or indeed the mother and father, being ostracised, bullied in the community, or indeed be at risk of harm? Does the mother and father have mental health issues that may be adversely impacted upon by the extended family being notified? These are all important questions that need to be considered. The availability and durability of confidential information. And again, This comes down to attempting to identify, if at all possible, the father and indeed the identity of extended birth family members. A point that Peter Jackson LJ raises, which I think is particularly pertinent, is that in the modern world, secrets are increasingly difficult to keep. And if notification isn't provided to the birth family and to a father, what will happen in the future if they find out at a later date? The implications upon the mother could be quite significant. The impact of delay needs to be considered, as well does any other relevant matters. The list of relevant factors is not closed, and each case needs to be treated on a case-by-case basis. The right of confidentiality is, as the Court of Appeal reminds us, exceptional, and it's highly exceptional whether father has parental responsibility or whether his family life under Article 8 found to exist. So that's a point that needs to be considered in each case. It goes without saying, in my view, that every local authority in its capacity as an adoption agency, and indeed every CAFCAS officer, will need to familiarise themselves with the key elements of the guidance I've set out within this presentation. So I hope this helps not just social workers and guardians, but indeed the legal representatives who are dealing with these cases in future. I would recommend strongly that the whole of the judgment is read. It's long, but it's very useful.